Let's now move to the courts. And today, former President Zuma's attempt to appeal a dismissal to privately prosecute the president was denied. Yesterday, you'll remember, in another court, Zuma was denied leave to appeal an earlier ruling which stopped his attempts to privately prosecute journalist Karen Moore and the state prosecutor in his corruption case, advocate Billy Downer. Both matters relate to Zuma's accusation that Downer leaked his medical records to Moore. Zuma then accused Ramaphosa of being an accessory after the fact in the matter. All of this, of course, has been refuted. Let's discuss what's going on. I'm joined now by visiting Professor Mia Swart. She's with Wits Law School. Prof, thanks so much for joining us. You know, I had to read that intro so slowly, even though I wrote it, and checked everything, because it's so detailed and so confusing. And we're dealing with private prosecutions where he's already been denied, and now he's trying to appeal. That's been denied. Two unsuccessful appeal attempts in as many days. Is this a sign that the courts are becoming less tolerant of Jacob Zuma's litigious nature, or that his cases and his attempts at cases are getting flimsier and flimsier?
I would say it's the latter, because the courts would still want to, certainly be, unbiased in hearing his cases. So if there was substance or sort of legal grounds for what he was, presenting to them, they would take that seriously still. But, this case today was called unlawful, an abuse of process, and unconstitutional. So it simply has no grounds, this case against Cyril Ramaphosa, President Ramaphosa. And that's why, they had to refuse him leave to appeal. So, he doesn't even have any sort of subjective ground to stand on in terms of the courts being biased, or, one doesn't even need that.
So he's been denied, but can he still, because we've seen this happen in the past, can he make a direct appeal on his own behalf to the Supreme Court of Appeal in Bloemfontein? Is that still a possibility for him?
It's now very unlikely that he can appeal, because appeal has been denied on the High Court level, and he would have to sort of again show that he has a prospect of success, that there's exceptional grounds to go to the SCA, which he simply doesn't have.
Could he go to the Constitutional Court?
Well, again, they would have to give him leave to appeal, which is equally unlikely.
Yeah.
More unlikely, yes.
Of course, I think what we've seen is how he just keeps going, though,
Right.
and people often call it the Stalingrad approach. But let's talk about this costs order that he was given.
Yes.
Just explain what that is and when it's given.
Right. So the cost order today was quite interesting, because it's called a party-to-party cost order, which is different from a punitive cost order, which one would have expected, because in the original case, a punitive cost order was made, which was called an attorney-client cost order. So the cost order today was in some sense less punitive, and to me it would have been logical if it was an attorney-client cost order again. It simply means that, the unsuccessful party has to pay all the legal costs of the successful party. And, this is standard in our law. So these cost orders, it's one way of wrapping someone over the knuckles if they've abused the law.
But you say it wasn't
Yes.
a punitive cost order. When is a
Right.
punitive cost order given?
So a punitive cost order is still fairly unusual. So it happened in the original case, where the court said that his case against Cyril Ramaphosa was based on ulterior motives, and that, it simply didn't have substance in law. So that's the unusual thing, that the punitive cost order was given, as a result of the original case, but then in terms of the appeal, it was just a lighter cost order, if you will. So cost orders are one way of punishing a vexatious litigant. Clearly, in the case of Jacob Zuma, this is not enough, because it has not, ever stopped him from litigating.
I mean, we heard phrases such as abusive court process in this matter. What is an abusive court process? Is that different from being a vexatious litigant, vexatious litigation? How are these judged?
Right. It's not really different. It's not really different. What could happen is our law allows for someone to be declared a vexatious litigant, which is if you clearly just use the law for purposes of harassment or, you know, sort of unsavory purposes, and you are not basing your claims on law. This happens very rarely, though. The threshold is very high. And someone would have to have the guts to actually bring such a case against Jacob Zuma, which hasn't happened somehow. But there's not really a difference between abusive law and, you know, being a vexatious litigant. It's pretty similar, and I would say in terms of abusing law, it's certainly happening if you are simply, you know, not basing your case on any law. Sorry, I'm being slightly repetitive, but that is at the heart of the matter here, is that he, you know, named Ramaphosa as an accessory to that case against Downer and Moore, but he has never completely explained what that even means, because there's certainly no grounds for any criminal case, and, you know, no grounds for a civil case.
So, as you say, you know, someone actually has to bring a case saying this is a vexatious litigant.
Right. And
no one's done that. So until such time. So
sorry, if I can come in there.
Yeah.
So one gets declared a vexatious litigant. So that means then that a senior judge has to give you permission to litigate, you know, from that point onwards. So this is, for political reasons, probably unlikely to happen. I think that, you know, one would have to hope that he somehow runs out of money, which has also not happened, or that, yes, that he, I mean, at some point, you know, you cannot keep appealing. So I think that this stage might now have been reached where the High Court has, you know, stopped him from appealing.
Yeah.
Yes.
I mean, you spoke a little earlier about punitive costs orders,
right.
Which they decided not to institute in this particular case this time round. What other ways are there to dissuade someone who is going to court for the sake of it when there just doesn't seem to be any substance?
Yes, I was asking myself that many times. I think that probably no legal system in the world has a way of really stopping someone who's as determined. It's a question of possibly bringing, you know, you can bring a case against someone and say that that person is instituting a malicious proceeding. This is another alternative which is not used very much. The Constitutional Court has a mechanism called constitutional damages, which has a punitive element, but that only happens on constitutional level, and that's also hardly used. So one really needs to think of perhaps the Law Reform Commission tackling this issue of, you know, just wearing out the courts, yes.
Yeah, wearing out the courts, absolutely. And if he has, you know, supplies of funders who will pay for it, he can carry on for a long time. Of course, the suspicion is that this is all being done to delay his arms deal corruption trial.
Right.
Could there be any kind of court action around that, saying we suspect this is being done to stop you answering in this particular case? Can you do that?
That is possible. My own sense is that, you know, the case against Moore, for example, could have been quite personally motivated and could have been, you know, an attack on the media, you know, an attempt to silence the media. I am not so sure that he's that concerned about his corruption case anymore. He seems to be the cat with infinite lives, so I very much doubt that he seriously believes that he could be sent to prison still. But, you know, he's had sort of, you know, a good innings with these cases, so he might just, continue to do so. Yeah.
Well, yes, we'll have to wait and see, I guess. Thank you very much. That is visiting Professor Mia Swart from the Wits Law School.